Legal page 11, 3, 2, 1, start. Para. On this ground, he justifies the petitioners having moved the tribunal for transfer of the cases to the Special Duty Commissioner. One of the problems in the way of the tribunal apparently was that normally the power to transfer is not a power which would have vested with that forum, and consequently it does appear that the tribunal felt handicapped in the face of this position. More importantly, however, since the case had been remanded to the tribunal, and since it was a substantially part heard matter, the tribunal expressed the view that it was competent to hear and decide the dispute. Mr. Srinivasan's contention is that in the face of the legal position, the tribunal's order is unjustified and that therefore the same ought to be quashed. Para. On behalf of the respondents, I have heard the different counsels. The first submission canvassed by them is that the application has been made very late, that the proceeding is substantially part heard, that even if the applications were to be granted for any reason, that it would only elongate and dilate the litigation, and the learned counsel brought it to my notice that unlike the petitioners, the respondents are people of ordinary means and effectively small persons who are fighting for their rights, and that in this background any restarting of the litigation would be disastrous to them. The reason why the learned counsel highlighted this aspect of the case was because they wanted to demonstrate to this court that real prejudice would be caused to the respondents if the applications were to be granted, and they submit that on the ground of delay alone, these writ petitions should be dismissed. Para. As far as this aspect of case goes, I am in full agreement with the respondents' learned counsel, because this litigation has been raging for a very long time, and the length of the litigation works very adversely as far as the respondents are concerned. Also, it is well settled law that even valid contentions must be raised in good time, and if they are raised at a very late stage, that a court would normally refuse to consider them. I need to record without hesitation that in any other situation I would have straightway upheld this ground and dismissed the writ petitions. I am setting out the reason why I am not doing so. It is the very considerations that I have referred to above that stops me from dismissing the writ petitions because if that is done, the tribunal will have to proceed with the hearing of the cases, which means that the recording of the evidence will have to be completed. This being hotly contested cases, the arguments will take some time and the tribunal will have to dispose of the case through a detailed speaking order, and if at the end of that process the petitioners challenge the validity of the order purely on the ground of want of jurisdiction, it would totally and completely frustrate the entire effort that has gone into the operation.